Yes, good evening to everybody. And today is the time changing would be there because I traveled from the Acharya Nagarjuna Institute to Hanamkonda. So I was a bit late. I reached my home at 8:10. That was the reason. Okay, read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Hurry up. I said, read what I posted on the screen.
General defense, plaintiff, the wrong gender.
Wrongdoer.
Sorry, sir, wrongdoer.
Read Professor Dr. Mohammed Saheb Hussain, Law of
Law of
Thoughts.
thoughts.
Yes, now let us go to that where I stopped in my last class yesterday. Then I will stop this video so that you could have the brand with the more. So yesterday that we are the warranty not fit injury is a complete defense. It is a complete defense, but the defense of contributing negligence came after the passing of this act. Then the Law Reforms Contributing Negligence Act of 1945. In contributing negligence, the defendant liability is based on the proportion of the fault in the matter. Up to that extent, we read it. Yes, this is what is the sign here? What is the sign which I highlighted yet? What do you call the sign? Unmute and give me the answer. If you don't know, you can say pass on. This one.
Pass on, sir.
Asterisk. Asterisk. Asterick. That is the. See, I will show you also now. Spelling is Asterisk. Asterisk. See, here it is there. Asterisk. That is the Asterisk is a free and open source framework for building communication, and it is one of the sign. It is a sign. Okay? Is it clear?
Yes, sir.
It is not a star. It is asterisk. See here asterisk. It can be there. See a small star-like symbol. Did you see it here? Here, a small star-like symbol used in writing and printing as a reference mark to the indicate omission, doubtful matter, linguistic figure, a star-like used to mark an utterance that would be considered ungrammatical. A sign would be there because that sign I shown because I dealt up to that extent in my last class. So that is the sign I put it over there. Okay. Now contributory negligence is there, then generally suppose the 20% contributory negligence is there. That means out of the 100, 20 will be deducted and 80 will be paid to you because your contribution for the negligence is 20%. Suppose if the contribution is 40%, how much the deduction would be there from the 100?
60%.
Suppose the contribution is 40%, how much the deduction would be from the 100?
60%, sir.
60%. So if the 50% is there,
50, sir.
only 50 will be deducted, 50 will get it because his contribution is there. So in warranty not fit injury, the plaintiff knows the nature and extent of the danger which the encounters in the case of the contributory negligence on the part of the plaintiff. He did not know about any danger. So let us see that the act authorized itself unlawful. So now let us see the one of the case law, how it can be made. If voluntary consent is given for an act that is not allowed under the law, the actor will be liable for the damages if the consent was there. In this case, the defense of warranty not fit injury will not be applicable. So, suppose somebody will give the consent. Okay, you cut my one finger and give me this much amount. Can you make a contract like that? Yeah. Can you make such a contract? You cut my finger and give me my money. Answer no.
No.
No, sir.
Answer no. Suppose if you are working in a mine and your fingers are chopped out, then you will get the compensation there. What is the leg big toe is called what is the big toe? There is a more money would be paid in the mines if the big toe was chopped because of the coal or some injury. What is called the big toe? Leg. I told you already. I don't know why you forgetting.
Yesterday only you said.
I told you already. HALUX, hallux. I told you.
Yes, sir. Alex. Yes, sir.
See, this is the hallux. I will show you that. Did you observe here hallux?
Yes, sir.
This. Spelling HALUX. X, hallux means bottom annattu. Okay. If the big toe is chopped out there, then the compensation is more there in the coal mine. So nobody would have such a contract in that way. So now, if the defense is there, voluntary not-fit injury is also not applicable in cases of negligence, as the basic constitution of the doctrine is consent, whether implied or expressed. But if due to some act of the defendant, the plaintiff is not left with ample time to choose, provide the consent or not, there can be no agreement to suffer harm from the said act. And where these are the things. Suppose the necessity, one will work under the mine, either it is a shaft or incline or open cast. It doesn't mean that they have given the consent for the death. Are you following me?
Yes, sir.
Sir.
So if they got injured, it doesn't mean that it is a voluntary not fit injury. It means they have given the consent to work over there. No, for the livelihood they are working. Are you following me?
Yes, sir.
Yes. Now let us see plaintiff, the wrongdoer. That is it is the second defense. What is the first defense?
Voluntary not fit injury.
Voluntary not fit injury. See, 2 days we discussed it. What is the last defense?
Statutory authority, sir.
Yes, I appreciate. At least you could remember now. See, that is the way to remember the things. Always you have to read, recite, and review. Now let us see the second defense is plaintiff, the wrongdoer. If the plaintiff itself committed a mistake, can he ask for the money? No. So now let us see. The maxim is there. If you write this maxim in the examination, and I'm sure that the examiner will be inflated. Inflated means పొంగిపోతాడు అన్నట్టు. ఇన్ఫ్లేట్ అంటారు చూడండి, గాలి కొడతా ఉంటే టైర్ ఏమవుతుంది, ఇన్ఫ్లేట్ అవుతుంది.
Yes, sir.
ఇది బైసికల్లో గాలి తీసేస్తే ఏమవుతుంది,
Deflate, sir.
డిఫ్లేట్ అవుతుంది. Inflate means when you pump the air into the tube, of course now the tubeless tires are there. If you pump in the tire or tube, it will inflate. Suppose if you remove the air, it deflate. So here, if you write the exturpi causa non aritor actio, then examiner will be inflated and you feel more happy because you know the maxim. So you have to behat it. Exturpi causa non aritor actio or actio. So you have to behat it and you have to write it. Only that there is only the method which says that from an immoral cause no action arises. That equivalent is. Suppose if you could not know exturpi causa non aritor actio, at least you write the English equivalent. What is the English equivalent?
Can you repeat once again, sir?
From an immoral cause no action arises. So if the immoral cause there is no action arises here, if the basis of the action by the plaintiff is an unlawful contract, then he will not succeed in his action and he can't recover the damages because it is an unlawful contract. See, if the two thieves, they made a contract. Whatever you loot means you take from the home of somebody else. Let us make 50-50. Okay. They made such a contract. Of course, they got it. There was a quarrel. Then he said, no, I committed a lot of work and you are outside the house and I am the inside the house. So my percentage is 80 and your percentage is 20. And can they go to the court?
No.
Because the theft
No,
itself is
sir.
wrong. Are you following me?
Yes,
Yes,
sir.
sir.
Then how could they go to the court? సార్ మేము దొంగతనం చేద్దాం సార్, సగం అనుకున్నాం సార్, ఇప్పుడు వాడు ఇత్తలేడంటే ఏమంటాడు, అరే మీరు దొంగతనం చేయడే తప్పు కాదురా అని ముందర లోపటైంది రవిన్లీ అంటారు. అది ఫాలోయింగ్ మీ?
Yes, sir.
అది ఎక్స్టర్పీ కాదా నారారిటర్ యాక్సియో అంటే అర్థం. That means from an immoral cause. The immoral cause? Theft. No action arises. No action arises for immoral cause. So if a defendant asserts that the claimant himself is the wrongdoer and is not entitled to the damages, then it does not mean that the court will declare him free from the liability, but he will not be liable under this head. But generally, see, when you make a contract, try to keep the contract. When you make the promise, don't break the promise. First, you don't make the promise. If you make the promise, but don't break it. Okay? But there should be a what promise it is? Not legal promise. That is not illegal promise. Okay? So let us see one of the case law, Bird versus Halbrook. Yes, anyone can read the case law? You read this case law? Yes? Anyone can unmute and read.
In the case of Bird vs. Holbrook, the plaintiff was entitled to recover damages suffered by him due to the spring guns set by him in his garden without any notice for the same.
Yes, because in the garden, that is of course, that is a tulip garden or any garden, doesn't matter. In the garden, nobody should have to allow to go inside. But suppose somebody goes over the trespasser and he will not, if he got injured over there, he will not be liable. But if he keeps the spring guns or any dangerous thing, you have to keep the caution board. Like if you keep on a boundary, there is a live electric wire, what do you have to do? What do you have to do?
Caution board.
What is a caution board? What should be written on the caution board? What sign would be there on the caution board?
Be careful.
You can write be careful live electric wire. Or you can write 230 kV electric words. Or you can write danger. You can write one skull and two crossed bones. ఏంటిదండి?
Yes, sir. Danger sign.
What is that? One skull, dangerous signature. That is a symbol, that is dangerous sign image. See, I'm showing dangerous sign image. What you observed?
Yes, the first one, sir.
The first one. What is the first one? The skull and
two cross bones.
two crossed bones. That is danger.
Yes.
And another danger also there. Of course, these are different, but danger generally you will write in this way. This way. I'm showing, cursor. This way that you write it. So, in English, how do you say danger?
Danger sign.
One skull below two crossed
Bones.
bones. That is the way to say danger. Okay. So now let us go to our studies. So a danger signal should be there. And even spring guns also dangerous things. Or mine betting అనుకోండి. Mine అంటే తెలుసా అండి? తెలుస్తే, if you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
దట్ మైన్స్ ఎక్కడ పెడతారు తెలుసా అండి? దారిలో కింద పెడతారు. ఆ పైన పిన్ ఉంటుంది. దాని మీద కాలు పెట్టింది అనుకోండి, అతవే అవుటే. దాన్ని మైన్ అంటారు. చూసారా ఎప్పుడన్నా? ఐ విల్ షో యూ హియర్ మైన్. ల్యాండ్ మైన్స్ పెడతారు, చూసిండ్రు? ల్యాండ్ మైన్స్, ఎక్స్ప్లోజివ్స్ అదే మన బ్రిడ్జ్ కింద కూడా పెడతారు. పోతుంది అనుకోండి, ఇది ఇక్కడ మైన్ చూపెడుతున్నా చూడండి, ఇది ఆ పైన తొక్కిర్రు అనుకోండి, ఇక్కడ ఖతమే, బ్లాస్ట్ అవుతుంది. ఇది ఇక్కడ చూడండి, బ్లాస్ట్ అయింది. ఇక్కడ చూపెడతాను చూడండి, ఎట్లా బ్లాస్ట్ అయింది చూసారా? దీన్ని మైన్ అంటారు. ఓకే, ఆ మైన్ సేమ్, అది కూడా మైనే. కోల్ మైన్ ఆల్సో మైనే. కానీ అది దట్ ఈస్ గని అన్నట్టు. అది that is a different thing. That is a land mine. This is a explosive. So mines. Suppose if you keep the mine in your land, somebody goes over there and will become a powder అయిపోతుంది మామూలుగా. So that was so much powerful this mine is there. So if you keep a mine in your garden, you have to keep a caution board. because it's a dangerous thing. Mine is a mute చేయాలా ఇంటికాడ సప్లో వస్తానే మీకు సందీప్ దాసరి mute it. Okay, so here also if you keep the spring gun in the garden without keeping the caution board, that means he will be held liable. Okay, now let us see the next case law. Yes, anyone can read this case law? Pitts versus Hunt case law. Read. Unmute and read.
In Pitts versus Hunt, there was a rider who was 18 years of age. He encouraged his friend who was 16 years old to drive fast and under drunken conditions, but their motorcycle met with an accident. The driver died on the spot. The pillion rider suffered serious injuries and filed a suit for claiming compensation from the
Relatives of the deceased person.
Till here only I can yes. Relatives of the deceased person. This plea was rejected as he himself was the wrongdoer in this case.
Yes. So, who is the rider? Who is the rider?
16-year-old man.
A person who rides the motorbike is called the rider. And who sat at the back is called?
Passenger?
Motorcycle వెనక కూర్చున్న వాళ్ళని ఏమంటారండి?
Passenger, sir?
నా పిలియన్ రైడర్ అంటారు. ఇక్కడ చదివింది కదండి ఇప్పుడే.
Yes, yes.
అందుకోసం ఇది దాచిపెట్టాను నేను ఇట్లా.
Okay.
Okay, there was a rider, means a person who is riding the motorbike was 18 years of age, and he encouraged his friend who was 16 years of age old to drive fast under a drunken condition. But their motorcycle met with an accident. The driver died on the spot. Means the rider is died on the spot. The pillion rider means a person who sat at the back of the rider is called the pillion rider, suffered serious injuries and filed a suit for the claiming the compensation from the relatives of the deceased person, means rider. This plea was rejected as he himself was the wrongdoer in this case. Why they are not entitled to get any compensation? Tell me.
Because he himself set the 16 years old to drive. That's actually
Number one,
wrong.
they should have the license. Number two, drunken driving one should not do. Suppose if the drunken driving do it, they will be responsible. Are you following me?
Yes, sir.
Yes, sir.
Whether the plaintiff is not the wrongdoer here?
Yes, sir. Plaintiff is wrongdoer.
Because it is he who encouraged the person to drink more. And both are drunken condition. In the drunken condition, if you drive it, what will happen? You lose the balance and you will meet with an accident. In the accident, the rider died on the spot. But the pillion rider, he got the injuries. And the compensation filed for it, they say both are wrong. Because your contribution for the negligence is how much percent? 100%. If the contribution is 100%, how much you are going to get it?
0%.
Zero. If your contribution for the negligence is 100%, how much you are going to get it?
0%.
0%. If the contribution is 80%, how much you are going to get it?
20%.
20%. Suppose if you don't wear the helmet, how much the deduction would be there?
No, sir.
20%. 20% deduction is there. Suppose if you are getting 100 rupees, at the time you did not wear the helmet, that's why your contribution for the accident is 20%. Means that will be deducted and 80 will be given. That is called apportionment of damage. Yes. Apportionment. And portion chestaru. What is your portion in the accident? 20%. Deduct the 20%, give the 80%. You did not wear the helmet. How much the deduction would be there? 20%. Okay, redeem the 20%, give the 80%. If you don't tie the seat belt, 20%. So there is a percentage is there. You remove it, then the rest of the amount will be given. Because your contribution for the accident is 20%. Is it clear?
Yes, sir.
How many cases are there in this extirpi causa non arbitractio? Only 2 case laws are there. Number 1, Bird versus Holbrook. This is spring gun case law. And number 2, Pitts versus there is a pillion rider case law. So this is the way you have to remember the things. Pitts versus pillion rider. Because Pitts, P-I-T-T-S, Pitts, అంటే పిలియన్లో కూడా P వస్తుంది చూడండి, PI వచ్చింది చూడండి. సో దట్ ఈస్ ద వే యూ హ్యావ్ టు రిమెంబర్ ద కేసెస్. Pitts and okay, pillion rider case law, okay, wrong, we would remember. Then you can write the story. Story also you have to write depending upon the marks. If the 5 marks are there, you cannot write the 10 pages story. Are you following me?
Yes.
Yes. So how many cases are there total? Bird versus Holbrook and Pitts versus Hunt. 2 cases you have to cite it when you want to say extirpi causa non arbitractio. Okay? Say yes.
Yes, sir.
Okay, now the inevitable accident. Inevitable accident means he wants to try to escape the accident, but at last a little back touched it and got the accident. We did not expect such a thing is going to happen. He tried his level best to avoid the accident, but still it is happened. That is called the inevitable accident. Accident means an unexpected injury, and if the same accident could not have been stopped or avoided, instead of taking all due care and precautions on the part of the defendant, then we call it an inevitable accident. It serves as a good defense, as the defendant could show that the injury could not be stopped even after taking all the precautions and there was no intent to harm the plaintiff. Because if all of a sudden a student or a boy, a minor, crosses the road where there is a zebra crossing, where there is no zebra crossing, and where there is no school zone, and if it is a highway, naturally we cannot make it out, because he tried to swerve to one side, but still the back portion hit the boy, so he got injured. At the time, he is not going to get any compensation. But because of a boy, people say, no, you have to pay the compensation, because the poor man doesn't know how to cross it, but you know how to drive it. Are you following me? Yes? Tell me.
Yes, sir. Yes, sir.
Why? Because a carman is having a deep wallet, means money more. So they generally ask, okay, you pay for that man, because the boy doesn't know where to pass and where not to pass. But you are a matured person, you know how to drive. Are you following me? Say yes. Okay, read another case law. Anyone unmute and read this case law? Read.
In Stanley West Powell, the defendant and the plaintiff went to a pheasant shooting. The defendant fired at a pheasant, but the bullet, after getting reflected by an oak tree, hit the plaintiff and he suffered serious injuries. The incident was considered an inevitable accident and the defendant was not liable in this case, sir.
What you did not understand the word here in this case law?
One
What
is
you did
pheasant
not understand the word in this case law?
One is pheasant shooting, sir.
Do you know what is pheasant? Do you know what is pheasant?
Don't know, sir.
See, this is the pheasant. Is it visible?
It's a bird. Yeah, yes, sir, it's visible.
It is like a bird. It is also people will eat. People will eat. You know, kauzu pita. Do you know?
Idea less, sir.
I will show you the kauzu pita to you now. In English లో ఏమంటారండి కౌజు పిట్టను? సార్ అస్సలే మాకు తెలియకపోతే మళ్ళీ ఇంగ్లీష్లో ఎందుకు అడుగుతాను సార్? అసలు మాకు తెలియదు, మీకు చూపెడతా. కాయిల్ అంటారు దాన్ని, ఏమంటారు? కాయిల్ ఇమేజెస్, కౌజు పిట్టను చూసారా? గుడ్రు గువ్వాలంటారా? ఇంత తెలుగులో ఏమంటారు దీన్ని? చిన్నగా ఉంటాయి చూడండి. ఇది ఈజ్ వెరీ డెలిషియస్. It cures many diseases, and its eggs are very, very nutritious.
Hamzullah, sir.
Yes, very nutritious, and it's very healthy food. It is halal and ఎవరు తినచ్చు. ఎస్ కౌజు పిట్టలు కూర అమ్ముతారండి. కౌజు పిట్టల కూర ఆంధ్ర ఏరియాలో అడుగుతారు. ఇవాళ తిన్నా నేను కౌజు పిట్ట. ఏది నేను మంగళగిరిలో దిగాను. మంగళగిరిలో దే ఆర్ కౌజు పిట్టాను ఉన్నారు. సో ఐ టేస్టెడ్ టుడే. ఇట్ ఇస్ వెరీ టేస్టీ అండ్ వెరీ గుడ్ ఫర్ హెల్త్. నేను పోస్ట్ చేస్తాను చూడండి మీకు, హౌ ఫార్ ఇట్ ఈస్ ఎ గుడ్ ఫర్ హెల్త్. దిస్ ఈస్ కాల్డ్ క్వాయిల్. ఏమనాలా? క్వాయిల్ అంటే కౌజు పిట్ట అన్నట్టు. సో ఇఫ్ యూ మిస్ మై క్లాస్ యూ మిస్ మెనీ థింగ్స్. ఇప్పుడు మీకు ఫీజెంట్ చూపెట్టానా? ఫీజెంట్, దిస్ ఈజ్ అ ఫీజెంట్. ఇట్ ఈస్ లైక్ ద సేమ్. ఇక్కడ చిన్న చిన్న చూడండి, ఇట్లా అట్లనే కనబడుతుంది, కానీ దానికి తోక ఉన్నది చూడండి ఎక్కువ. టైల్ ఈజ్ మోర్. ఇట్ ఈస్ లైక్ ఎ కాజు. ఇట్ ఈస్ వెరీ డెలిషియస్. ఫీజెంట్స్ ఆర్, దట్ ఈ స్పెల్లింగ్ ఈజ్ PHEESSANT. మామూలు మరి పీజెంట్ అన్నాం అనుకోండి రైతు అవుతాడు. ఇది PHEASANT పీజెంట్. అది పీజెంట్ అయితే PEASANT. పీజెంట్ అంటే ఏ టిల్లర్. ఆర్ యూ ఫాలోయింగ్ మీ? ఇప్పుడు H is there, it is a bird. If H is removed over there, a tiller, a person who tills the land, a small land, and he called the peasant. So they went for the peasant shooting, and the defendant fired at the peasant. So one defendant, there are two parties are there. Then one defendant fired for the peasant. It sat on the oak tree. Oak tree. Oak is a very hard tree. I don't know whether you saw the oak trees or not. There are many oak trees, especially in the cold seasons. Very long would be there, and its timber is very hard. And this oak tree and this pellet, bullet or pellet. Pellet means a small one. The pellet and bullet, and we can say both the things, because somewhere the pellet is written, somewhere the bullet is written. But pellet is the right word. The pellet, it is touched the oak tree branch instead of pheasant, then took the way. ఒక స్పీడ్ ఉన్నది, ఒక టచ్ అయింది అనుకోండి, అది గ్లాన్స్ ఆఫ్ అంటారు. అంటే తిరిగి వచ్చేస్తుంది. తిరిగి ఎడిపోతుంది, వేరే డైరెక్షన్ వెళ్ళిపోతుంది. వాట్? ద బుల్లెట్ ఆర్ pellet. సో ద pellet, instead of touching the pheasant, it touched the oak tree branch, which is hard, and it took that is glanced off అంటారు దాంట్లో. యాక్చువల్లీ it is a glanced off is not here. GLANCED, గ్లాన్స్డ్ ఆఫ్ అంటే రిటర్న్ వచ్చి వస్తుంది. ఇప్పుడు మనం స్ట్రైకర్ కొడతామని చూడండి క్యారమ్ బోర్డులో. స్ట్రైకర్ ముందట కొడితే ఎటు వస్తుంది అంటే అది మళ్ళీ ఏ యాంగిల్లో కొడితే ఆ యాంగిల్లో మళ్ళీ ఎరకకి వస్తుంది. అది ఫాలోయింగ్ మీ? స్ట్రైకర్ తెలుసు కదా, క్యారమ్ బోర్డ్ యాంగిల్ ని మనం బట్టి ఎట్లా కొడితే మీరు అట్లా తిరుగుతుంది అన్నట్టు అది. సో ఇఫ్ దే ఫుట్ ఎట్ ఇట్ ద పీజెంట్, ద pellet has touched the oak tree branch and took the different direction, because the energy kabatti it took the another way. So in another way, another party was there, and they are also gone for the shooting. So it hits one of the another party, which is at the adjacent side, the other side or adjacent side. So one of the fellow got injured. So such a injury is an inevitable accident. The incident was considered to be the inevitable accident, and the defendant was not liable in the case. Endukante, why the defendant is not liable? Tell me. He wants to shoot the
pheasant,
but the pellet,
it flew away, and the person who
touched the oak tree branch and took the different direction and hit the another person, another shooting party person, or another person who is a distance should be there. So he got injured. But whether the first shooter want to shoot that the person injured, no, he want to shoot
the
pheasant. But the pellet, instead of touching the pheasant, it touched the oak tree branch and it glanced off and returned to the another direction, and where the plaintiff got hit and he was injured. So naturally, one cannot see that the thing is going to happen. So they say it is an inevitable accident. It is not intentionally did an accident, and it is by the see his fate is not good. That pellet, generally pellet వానికే తలగాలని ఉన్నదండి ఇక్కడ. Are you following me?
Yes.
Yeah. సో కిస్మత్ ఖరాబ్ హై అంటారు దాన్ని.
Yes, sir.
So his fate is not good, or his luck is not good. His bad luck, that is. So such a thing is a Stanley versus Powell case law. It is a glanced off case law, pellet case law, and inevitable accident case law. So we have to remember the case Stanley versus Powell by hook and crook, by keeping some mnemonic value, or some keeping bandagurtu, or some keeping some other thing to remember it. Stanley versus Powell. You use your own mechanism and you have to make it out. So here Powell means P and Pheasant means P. So in that way also you can remember it. Pheasant Powell. So that was the case law. Now let us see the Assam State Corporation, cooperation, not corporation, cooperation, etc. versus Federation Limited, Srimati Anubha Sinha. So that is the case law. So Assam State Corporation, etc. Federation Limited versus Srimati Anubha Sinha. It is the premises which belong to the plaintiff or let out to the defendant. Premises means the place which is belong to the plaintiff. He let out to the defendant means కిరాయికి ఇచ్చేసిండ్రు. Let out అంటే తెలుసా అండి? To let అన్నట్టు. So let out to the defendant. The tenant, that is, the defendant, requested the landlord to repair the electric wiring of the portion which were defective. So who requested? Tenant requested. To whom? To the landlord. What they say? Because the electric wiring portion is defective. But the landlord did not take it seriously and failed to do so. Then what happened? Due to the short circuit, an accident fire spread in the house. No negligence was there from the tenant's side because the electric wiring is not properly installed. So there is no negligence on the part of the tenant's side. In an action by the landlord to claim the compensation for the same, it was held that this was the case of an inevitable accident and the tenant is not liable. Why tenant is not liable? Tell me.
Already he informed to repair the
He
electric wiring.
already informed the landlord to repair the electric
wirings.
wiring. నేను చెప్పాను, ఏది పైపులు వేసి వాళ్ళల్లో పెడితే వైరింగ్ ఏమంటారండి దాన్ని? నిన్ననే చెప్పింది అది. Now the wires will not be visible. Earlier olden days వైర్ల పట్టా పోతా ఉండే, చూసిండ్రా అండి బయటికి వెళ్ళి? Visible wires are there. Now can you see the visible wires anywhere in the house?
No, sir.
మరి దాన్ని వైరింగ్ ఏమనాలా? సార్ మేము ఎలక్ట్రీషియన్ కాదు సార్, మేము కాకపోతే తెలియదని చెప్పండి, నేను చెప్తా కదా. క్లాండస్టైన్ వైరింగ్ అంటారు దాన్ని. క్లాండస్టైన్ అంటే దాచిపెట్టిన వైరింగ్. స్పెల్లింగ్ క్లాండస్టైన్ వైరింగ్ అంటారు దాన్ని. ఓకే. So because it is electric proper, not the wiring is not proper, so it got the short circuit and the house is burnt. That means tenant is held liable. Sorry, tenant is not liable because he informed to the landlord several times, but the landlord did not repair it and replace it. Hence, it is an inevitable accident. Which one is Assam State Cooperation Federal Limited versus SMT Anubha Sinha? That is the case law. సార్ ఎవరు ప్లేంటివ్ సార్, ఎవరు డిఫెండెంట్? మనకి ఎందుకు ఇవన్నీ? మనం ఆర్డర్ పెట్టుకోవాలా, ఎవరికి ఏమై అయింది అది ఫాలోయింగ్. ఎవరిని చంపిండు కాదు ముఖ్యం, అక్కడ చంపిండు ఎవడు అని కాదు ముఖ్యం, యాక్షన్ ఏమైంది ఇది ముఖ్యం. అది ఫాలోయింగ్. రామ కిల్డ్ రావణ. ఓకే, రావణ కిల్డ్ బై రామ. We are not worry about who is the doer and who is that. తర్వాత అది యాక్షన్ అయింది కదా. అక్కడ యాక్షన్ అయినప్పుడు ఒకరికొకరిని కొట్టుకుంటే ఎవరు లయబిలిటీ అవుతారు? ఎవరు లయబిలిటీ అవుతారండి? కొట్టినోడు లయబుల్ అవుతారా కాదా? సార్ ఫస్ట్ పార్టీయా సార్ సెకండ్ పార్టీయా? నీకెందుకురా బాబు, ఫస్ట్ పార్టీ ఎందుకు అవుతాడు తెలుసా? వాడు అప్పీల్కి పోయిందనుకో, అక్కడ వాడు ఫస్ట్ పార్టీ అవుతాడు అక్కడ. అది ఫాలోయింగ్ మీ.
Yes, sir.
లోయర్ లెవెల్ ఏమవుతాడు? ప్లెయింటిఫ్ ఫస్ట్ పార్టీ అవుతాడు.
Yes.
Is it clear?
Yes, sir.
When you want to study total means at least you have to spare 1 hour. ఎందుకంటే ఎట్ ద టైమ్ ఓన్లీ దట్ బికాజ్ ఇట్ ఇస్ రఫ్లీ 10 to 15 pages ఉంటుంది కేసులా, ఆర్ సమ్ టైమ్ ఇట్ ఇస్ మోర్ ఆల్సో. కేశవనంది భారతి కేసులా ఉన్నది, అది ఎన్నో పేజీలు ఉన్నది, ఎన్నో పేజీలు కేశవనంది భారతి కేసులా. సో మెనీ పేజెస్ ఆర్ దేర్ కేశవనంది భారతి కేసులా, బికాస్ వీ కెనాట్ రీడ్ దట్ ఎంటైర్ కేసులా ఓవర్ దేర్. సో వీ రీడ్ to certain extent what is the gist of it. So that is a thing, it is an inevitable accident. Then the next case law is, read, anyone can unmute and read next case law in inevitable accident. Yes, hurry up.
In Sridhar Triwari West, Uttar Pradesh State Road Transport Corporation, a bus of Uttar Pradesh State Road Transport UPSRTC reached near a village where a cyclist suddenly came in front of the bus and it had rained heavily, so even after applying brakes, the driver could not stop the bus. As a result of this, the rear portion of the bus hit another bus which was coming from the opposite side. It was
Yes,
known that there was no negligence on the part of both the drivers and they tried their best in avoiding the accident. This was held to be a case of inevitable accident. The defendant, that is UPSRTC, was held not liable for this act.
yeah. See, UPSRTC, is it a initialism, acronym, shortens or contraction?
Initialism, sir.
Initialism, because UPSRTC means we are uttering. Suppose if you say NATO, SATO, ICRISAT,
Acronyms.
POSCO, that means acronyms. Shorthand means, shorthand means APP full stop, application, important, IMP full stop, that is shortening. And where the apostrophe is there, that is called
Um,
contractions. Contraction. Why you are forgotten? We repeated several times.
Yes, sir.
Yeah. What is IE?
That is shortening, sir.
Yes, that is the Latin terminology. Id est.
Latin.
IDE, id est. EST, est means that is. That equality is that is. So what happened in this case law? A bus of UPSRTC, that is the Uttar Pradesh State Road Transport Corporation, reached near a village. Village there in the where a cyclist, a person who is riding on the cycle is called a cyclist, suddenly came in front of the bus, and it had rained heavily at the time. So even after applying the brakes, who applied the brakes? Driver applied the brakes. Of what? UPSRTC. And could not stop it, because why did not stop it in the rainy season? What will happen? సార్ అది జాగ్రత్త సార్, అది ఇంగ్లీష్లో చెప్పండి, ఇంగ్లీష్లో. సార్ స్లిప్లే సార్, మనిషి స్లిప్ అవుతుంది, అది ఏం, అది బస్, అది స్కిడ్ అంటారు దాన్ని. సో ఇట్ స్కిడెడ్ బికాస్ ఆఫ్ ది రెయిన్. అక్కడ రెయిన్లో కొంచెం మళ్ళీ ఆయిల్ పడ్డది అనుకోండి, ఇంకా బాగా స్కిడ్ అవుతుంది. ఆర్ యూ ఫాలోయింగ్ మీ?
Yes, sir.
Yes. In front of the bus, it had rained heavily, so even applying the brakes, the driver could not stop the bus. As a result of this, the rear portion and a portion,
Venuka portion, sir.
the back portion. So rear portion of the bus hit another bus. Eduku, to avoid the cyclist. So he turned to it, but it still the opposite the another bus a little touched at the back, another bus which was coming from the opposite side. It was known that there was no negligence on the part of both the drivers, and they tried their best in avoiding the accident. This was held to be a case of inevitable accident. The defendant, that is the UPSRTC, was held not liable for the act, because there is no intention to make such a thing. He tried to avoid the accident because the boy has come all of a sudden.
Yes, sir.
అయినా
Cyclist.
అది అయింది. accident అయింది. At last, it is just touched at the back of it. So such a accident is called inevitable accident. There is no intention to make such a thing. Whether there is an intention, no,
It is what intention.
because
If
he
it is
applied
intention,
it, bus skidded, swerved అంటారు దాన్ని. ఇమీడియట్ గా స్వర్వ్ చేసిండు, అది లెఫ్ట్ కో రైట్ కో డజంట్ మ్యాటర్. స్వర్వ్డ్ అంటే ఇమీడియట్లీ మేకింగ్ టు టర్న్ దట్ సైడ్. ఏం తిప్పాలండి? ఆ చక్రాన్ని ఏమంటారండి ఇంగ్లీష్ లో?
steering.
స్టీరింగ్, దట్ ఈస్ కాల్డ్ స్టీరింగ్. ఓకే, ఇప్పుడు అన్ని పవర్ స్టీరింగ్ వస్తున్నాయి, అంటే హైడ్రాలిక్ తో నడుస్తుంది. కొంచెం ఇట్లా చెయ్యి ఇట్లా అనగానే తిరిగిపోతుంది మొత్తం. ఆర్ యు ఫాలోయింగ్ మీ? పవర్ స్టీరింగ్ నౌ. So this is the Sridhar Tiwari versus UP State Road Transport Corporation swerving the bus, try to hit the accident, but the boy has come over there and the rear portion hit it, hence it is the inevitable accident. So next case law is, in the case of the Holmes versus Mather, this is another case law. The defendant's horse was being driven by his servant. Again, the horse is driven by his servant. Due to the barking of the dogs, and the horse became unmanageable and started to bolt. The spite of the every efforts of the driver, the horse knocked down the plaintiff. This makes it a case of an inevitable accident, and the defendant were held not liable for the incident, because it is the defendant horse was being driven by his servant. Okay, they are going. Okay, next, what happened? The dog barking was there. So the horse startled. And నేను చెప్పాను మొన్న, startled అంటే జంకింది తెలుగులో. The horse became frightened and became unmanageable and started to bolt. And started, it's moved out of the bolt. And in spite of every efforts of the driver, he tried to stop it. The horse knocked down the plaintiff, because the horse has came out of the cart and knocked the plaintiff. Or by the barking of the dog, the horse became unmanageable and he knocked down the plaintiff. That make it the case an inevitable accident, because of the barking of dog. Dog crying అనద్దండి, డాగ్ ని ఏమనాలా? బార్కింగ్. మరి పందిని ఏమంటారండి? గ్రోనింగ్ ఆర్ గ్రంటింగ్. లైన్ ఏమంటారండి? రోరింగ్ అవుతుంది. ఓకే, సో అట్లీస్ట్ యూ నో ఇట్, the each one how it can be, because there is a specific names are there. And what about the snake? Hissing. దాన్ని స్నేక్ ని బార్కింగ్ అన్నారు అనుకోండి, వీడు ఎక్కడికి వెళ్ళి వచ్చిండ్రా నాయన, ఎర్రగడ్డ నుండి వచ్చిండా, ఎక్కడికి వెళ్ళి వచ్చిండు, ఎక్కడ చదివిండు, ఎవరు చదివిపించిండ్రు ఇన్ని, కిందికి వెళ్ళి మీద, మీదికి వెళ్ళి కింద ఒక్కసారి చూస్తారా లేరా? Yes. So please use the appropriate word. If you don't know, you try to ask. If you want to know it, you can send me the SMS also. I will give the answer for that one. What makes the sound? సార్ మాకు కూడా తెలుసు సార్, నేను స్మార్ట్ ఫోన్లో కొనుక్కుంటాను సార్ అంటే కొట్టండి, మరి కొట్టి తెలుసుకోవాలి మరి. ఓకే, యూ కెన్ డూ ఇట్. హార్సెస్ ఏమవుతుందండి? నీ అంటారు దాన్ని, NEIH, నీస్ అంటారు. అదే మరి గాడిద బార్కింగ్ కాదు, అది బ్రాలింగ్ ఏమంటారు చూడండి. బ్రాల్ BRAW. Yeah, that is brawling. So each animal having a different sounds are there. ఇది మీకు లేదు సార్, ఇది కమ్యూనికేషన్ స్కిల్స్ ఫర్ లాయర్స్ అని ఉంటుంది. ఇందులో దేర్ విల్ టీచ్ ఇఫ్ ఎనీథింగ్ వాట్ ఇట్ మేక్ ద సౌండ్స్, హౌ ఇట్ మేక్ ద సౌండ్స్. దట్ ఈస్ వెరీ మచ్ ఇంపార్టెంట్ ఫ్యాక్టర్. అదే మళ్ళీ ఎలిఫెంట్ ఉన్నదనుకోండి, ట్రంపెటింగ్ అంటారు దాన్ని. ట్రంపెట్, ఎలిఫెంట్ ట్రంపెట్స్. సార్ అంత మీరు కొడతాను రా సార్, నిజంగానే చెప్తాను రా, కొట్టుడు కాదు, నిజంగానే చెప్తాను. ఎలిఫెంట్ సౌండ్, ఎలిఫెంట్ వాట్ యు డూ, ఎలిఫెంట్ గ్రంట్స్ అంటారా? ఎలిఫెంట్ మేక్ వాయిస్ ట్రంపెటింగ్, UMP, trumpeting. Elephant trumpets, sounds. Elephant sounds. Elephant sounds for kids. Elephants trumpet. చూసారా అండి ట్రంపెట్? చూసారా లేదా?
Yes, sir. Elephant
ఇప్పుడు
trumpet
వినబడుతుంది
sound or
చూపెడతాను
trumpet roll with.
మీకు. దెన్ I will show you. Are you hearing?
No, sir.
Yes, sir.
But we know, sir.
The baby elephant. So it is trumpeting under దాన్ని. What do you say?
Trumpeting.
Yes, because we have to make the experiment, if you want to hear the voice, and I have to remove the thing again, I have to keep the thing, then only me.
సార్ సార్థక నామధేయాన్ని ఏమంటారు ఇంగ్లీష్ లో?
ఏంటండి?
సార్థక నామధేయులు. సార్థక నామధేయులు సార్.
సార్థక నామదేవుడు.
దేయుడు అదే వివేకానందని అంటారు కదా సార్, సార్థక నామధేయుడు అని. అట్లా వాళ్ళని ఏమంటారు ఇంగ్లీష్ లో?
Because even I also don't know, but I will tell you later, because when I want to search it, no.
ఓకే సార్, థ్యాంక్ యూ.
Okay, because I have to search it, because I have not come across. ఇప్పుడు నాకు come across అయింది ఎందుకంటే because you asked me, no, it will increase my knowledge. Okay.
Okay,
so
sir.
here a horse became unmanageable because of the starting of the barking of the dogs, and then it is kicked off, and the plaintiff got injured over there, and it is an inevitable accident. Then the last case law that we will read it, then we will stop it. Brown versus Kendall. The dogs of the plaintiff and the defendant were fighting with each other. The defendant tried to separate them. While doing so, he accidentally hit the plaintiff in the eye, causing him some serious injuries. The incident was purely an inevitable accident for which no claim could lie. So the court held that the defendant is not liable for the injuries suffered by the plaintiff, as it was purely an accident. కుక్కలు మరుగుతా ఉంటే దగ్గర పోవద్దండి మీరు. ఆ మొరుగేటి వదిలిపెట్టి మీ పిక్క తింటాయి అవి. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
So the dog barking each other. So one fellow went over there and